my name is Jennifer Miller, and I'm one of the estate litigators here at Stokes Law. Today, we're going to discuss 3 ways to contest a will. First, let's start off with what is a will. A will is generally a legal document that defines how a person would like to administer the estate and who they would like to have administer their estate. If one of your family members disagrees with how the will has been written or their portion of the entitlement under the will, they can dispute the will in 3 ways. The first is that it was not properly signed. The second is that there was a lack of capacity of the person who signed the will at the time that they signed the will. And then the third one is that there was undue influence. So if we want to unpack those a little bit more, we could talk about what is needed to properly sign a will. Generally speaking, in Alberta, we need to have the testator, the person who signed the will, signed before 2 independent witnesses. And all 3 people need to be in the same room at the same time to sign the same document. Electronic signatures do not work. Signing in counterpart do not work. All people need to be in the same room. Additionally, if one of the witnesses is also a beneficiary under the will, that would also invalidate the will. So if you're receiving a benefit under the will, you should really have somebody else sign that will so that it does not look like there was any wrongdoings in preparing that will. Another thing that you would consider contesting a will is capacity. So a lot of times my clients come to me and say, look, my parent or my relative was on their deathbed in the hospital when they signed the new will. Can I contest it? And the answer is you could try to contest it, but being close to your death is not necessarily a reason that they've lacked capacity. The courts in Alberta have determined that capacity is a legal assessment based on the evidence available and not a medical diagnosis. So a person could have their capacity questioned if they have a medical diagnosis such as Alzheimer's and dementia, or if they're under the influence of drugs, or if they're under a guardianship order, or they have under a coma or something like those things. But that doesn't necessarily mean that they don't understand the effect of the will that they're signing, the value of their assets, and the implications that their will has on the administration of their estate to their intended beneficiaries. In many cases in Alberta, people who have diagnosed Alzheimer's or dementia have still been found to have capacity when they are signing their will. The third way that we can contest a will is whether there's any suspicious circumstances that might suggest undue influence. What you would need to prove is that there's actual and real coercion happening, which means that the person who is signing the will has been threatened in such a way to provide a benefit to somebody else, one of the beneficiaries, that they did not actually do this voluntarily. So people use the expression, there was a gun to my head, and so I had to sign my will. In my practice, I have never signed a will with anyone who's had a gun to their head. Generally does not happen, but what will happen is a client might come in with a group of people and say, to me, if I don't sign my will the way they want me to, they're going to do X, Y, and Z to me. Now that would be pretty concrete proof that there's coercion. The courts have been clear that having a close relationship with the person who's about to die is not a reason that there has been any undue influence. Having joint bank accounts with somebody at the time that they've passed away is not a reason that there's undue influence on its own, but the court will consider the circumstances together in a totality to determine whether it's likely coercion exists or not. There has been a recent case in Alberta that's come out where a widow was on her deathbed and signed a new will, and she called a lawyer, and that lawyer met with her in person at the hospital room and signed a new will with 2 of the nurses in the hospital. And that new will completely changed what she had written in her old will, which wrote out one of her children completely, as well as gave the majority of her estate to one of her sons and gave only a small portion to the other son. And the son that she gave more of the money to was actually living with her and helping her on the farm. So in Alberta, there was recently a decision that came out where the court said that a woman on her deathbed that signed a new will that changed her old will in a substantial way was still valid. And in that court case, the beneficiary who did not receive as much as they were hoping to receive did actually get an expert witness to come and compare the mother's signature from old signatures to her new signature, because one, her signature had changed, and that was a result of the court determined, she was in her final stages of life, and so it's expected that you wouldn't have the same strength. But the courts also said you can bring your experts, but the best evidence to have is the witness who saw you sign that will. In a lot of these competing claims, the court is very hesitant to step in and change a will that somebody has planned with a lawyer, signed with witnesses, who told the lawyer she understood the impacts and implications of this new will. She understood the assets that she owned, as well as she understood that she was in her final days of passing away. So in those cases, the courts are very hesitant to step in and challenge a will. It is extremely difficult to do so, and it can be expensive. So if you have questions about whether you would like to challenge a will or not, first thing is to get legal advice, to see if you even have a case, and also see if there are circumstances that give rise to some of these suspicious circumstances or even a properly executed will.